So, Wakili, please take us through the divorce process in Kenya step by step. This is a question that I've interacted with people for the last few months and they are asking.
Yes.
Some are telling you, I served her with the divorce paper, she has not signed. I would want them to get to know what is the step by step
Yes.
divorce in Kenya.
Okay. Thank you for that question. Um, and the first process, you first of all need to have a marriage. So the
Okay.
marriage need first to exist. I've
Yes.
had instances where we go to court and the respondent comes and says, look, this marriage is non-existent. You may remember there has been even some cases of some public figure where the court held that
You
they,
are not
if
married.
they could not have been married because each of them did not have capacity to marry.
Okay.
We'll get into the issues of capacity in some other
Yeah, because
some
where
other discussion.
capacity, all right.
Yes. So you need to have first of all an existent marriage. You need to have, how did you get married? Did you get married through customary means? Did you get married through a civil marriage wakati mnaenda kwa attorney general, or did you get married through the religious marriages, the
Islamic,
Islamic, Christian, the Hindu? So you need first of all to establish that. Then you need to to check if you have the grounds to divorce.
Okay.
Has there been cases of adultery? Has there been cases of desertion?
Yeah.
And desertion, we say it has to be
yes.
at least 3 years. Then you have to you may need also to explore whether there is yet another ground of cruelty. Cruelty is mostly the ground. Cruelty and adultery is what moves people to dissolve their marriages.
Okay.
But then you might also have another ground for dissolution of marriage, which I have called the irreconcilable differences. Yes. Once those grounds are established, you need to crystallize them in form of a document called a petition.
Okay.
This is where you take to court a description of what your marriage was and what are the issues that are ailing it.
Okay.
You take it to the magistrate's court. It is the court that is empowered to by statute hear and determine matrimonial disputes.
Okay.
So you file it there. Amongst the other documents you need to prepare is a document called a verifying affidavit. You need to verify the correctness of your petition, the divorce petition, and also to assure court that there is no other dispute pending before any other court between you two on the same issues.
Would you explain that?
That is to say, a court cannot listen or cannot hear and determine a dispute that is already subject of another determination in another court or before the same court. Okay. So the purpose of that verifying affidavit is to ensure that the court has, or rather, this dispute is non-existent in any other forum.
All right.
Yes. That's what the civil procedure rules require. So you prepare a verifying affidavit. This is to be signed by a person, by the petitioner or the cross petitioner. Okay. In a divorce. Then you also need to file a witness statement, and then you provide documentary evidence in form of maybe a marriage certificate, if there is one in existence. You may need to provide, say, birth certificates of the children that you may have. And you need to serve the other party. Service is not what you ordinarily enjoy in hotels. It is giving the documents. You are giving those documents that you've taken to court. Yeah. In form of a petition, in form of a verifying affidavit, in form of a witness statement, inform our list of documents and the documents themselves, and something called a notice to appear. Now, that notice to appear, you are notifying your spouse, your ex-spouse in waiting, that you have filed this case, and he's required to appear in court within 15 days.
Oh, okay.
Then once this respondent, your spouse, has received the document, he's supposed to file a document called a memorandum of appearance.
Okay.
You are telling the court that I have been served with this, and I'm here putting a memorandum that I'll be able to come and defend myself. Additionally, he's supposed to either file an answer to petition. That is when he's saying, look, those grounds are non-existent, or maybe that marriage itself is non-existent, such that the court will come to now interrogate, we know how to interrogate who between you is speaking the truth. Okay. If he or she, that is the respondent, if he or she, might be the man or the woman, is himself seeking for the dissolution of marriage through grounds that he has been caused by the petitioner, he can now file something called a counter or a cross petition. You are telling the court, forget about those grounds, so he does that through an answer to petition. Then he cross petition, where he's telling the court, as a matter of fact, it is not she or he who is wronged. It is not the petitioner. I am the one who has been wronged, and he will particularize his grounds or her grounds. He does that through something called a counter or a cross petition. That cross petition has to be supported by a document called a verifying affidavit as well. It has to have a witness statement, and it has to have the documents that you wish for the court to look at before it can pronounce itself in the divorce petition. Okay. So once that document is what we call the pleading stage. Once this person, the petitioner, has received those documents, he's supposed to file an answer to cross petition. Then, once the pleading stage closes, you are supposed to move the court to certify the matter as ready for hearing, either as defended or undefended, as undefended or undefended cause. And you file something called a notice of motion application. So you file you file a chamber summons. You may file a chamber summons supported by an affidavit saying that let have this matter proceed either as defended or undefended. It becomes defended whenever the respondent has filed his answer to petition or a cross petition. Okay. But when none is there, when the respondent has opted to ignore.
Yeah, because that was my next question. What happens when they decide you did not serve me? They don't even recognize that they have been served. Yes. Where do we go from there?
Now, when you say you are not served, it means that the matter cannot proceed until you are served. There is no case where you are a party and that can proceed in your absence if you are not served.
And the way to recognize that I was served is signing the very papers?
Not necessarily. This person there are many instances where people are served with papers and they refuse to append their signature on it.
Yes.
They just say, okay, I have seen it, but go your way, I will not sign anything. So what happens, the person serving swears an affidavit to say I met this person here, and I introduced myself and the purpose of my visit, and I gave him the document or I gave her the document, and they refuse to sign, although they retain their own copy. Okay. So if that's a proper service, signing or failing to sign is not itself a bar. All the court needs to have is an affidavit of service showing that indeed this person was informed and was even given the documents that have been filed in court. So after that procedure, so when you say a matter is defended, is when someone has refused to answer. He has refused to appear, and by appearance it doesn't mean in physical. It's when you file that memorandum of appearance. You appear through documents. You file a document saying, I have received your documents and I will defend. I enter appearance to say that I'm going to defend myself. And after that, he's supposed to file an answer to petition. And if he or she has a ground that they would want to contend in the divorce petition, he's supposed to file something called a cross petition. Then once that cross petition is filed, it's supposed to be supported by a verifying affidavit. So all these documents are supposed, once they have been filed, you file an application called the registrar certificate. It's merely a motion. A motion in court, you file to have the court certify matter ready for hearing, either is defended or undefended. That's why you file a chamber summons and a supporting affidavit, and then you pick a date at the registry. Then once the dates are picked, the first time when you go for hearing, you just go and the court is merely supposed to ask, have you received the documents? These are the documents in place. Are they well in order? If you are represented by an advocate, the court will not need to delve into the singularity of the documents filed, if they have been served, and whether the other party has responded. It is ordinarily expected that an advocate understands the process. But when it is the parties, the magistrate will find them asking particular questions. Do you have the petition? Do you have these other documents titled a witness statement? Have you also filed your witness statement? Have you provided me with the documents which you'll be hoping to rely on as evidence? Have you, all that? And then once they are certified that all the documents are in order and that each party has been served, that whoever is supposed to respond to a certain issue has responded, a certain document has responded.
Sorry.
Kameluka. Sorry. Nasikia hiyo divorce. So, tulikuwa tunafika hapo. Now, once the magistrate is certified that all the documents that each party was required to have availed he has already complied, he satisfied the matter ready for hearing, and allocates it for hearing for a certain date. And if it can also allocate the date for hearing and the magistrate to hear that divorce petition. Now, ordinarily, or the emerging trend is that courts no longer need to delve into the singular allegations, especially when parties agree that the marriage should be dissolved. I've seen courts try and sanitize the proceedings so that we don't end up washing our dirty linen in public. So they ordinarily ask you, did you have your statement? So people ordinarily adopt their statements, and then the other party will be asked to cross-examine with a limited time frame. This is particularly important.
How much time are we talking about?
Like the last divorce I handled, I think it was this last week. It was actually this week. The court told us to take 5 minutes. So the 5 minutes, you're barely asking, do you have evidence for this? Yes. Ordinarily, this is to ensure that everyone gets a fair chance for hearing. But you are almost assured that both of you are not in contention that the marriage is a proper candidate for dissolution. So the court will ordinarily allow parties to adopt their statements, produce their documents, and upon cross-examination, the other party will be given, the petitioner will be given a chance to be re-examined by his or her advocate. You may find that if we didn't have too much issues raised during the cross-examination, there will be very little examination.
Okay.
So cross-examination is when you are being asked questions by the advocate for the party who you have sued,
Yeah.
or who has sued you.
Mm-hmm.
But re-examination is when now you have a chance through your advocate to respond to those issues that were raised during cross-examination.
So is it a must that I answer?
You must provide an answer.
Okay.
You cannot assume not. You cannot fail to answer. You can say no. It's not a must that you give a particular answer, but you are supposed
But you
to
have to
speak the
give an
truth.
answer.
You have
Okay.
to give an answer. You might also say you don't know.
All right.
Yes.
As long as there is an answer given, it's okay.
Yes. Only that there is a concept in law called an adverse inference.
All right. Please
If
explain
if
that.
if you hide information that is peculiar to you, that is peculiar in your custody,
Yeah.
then court presumes that that information you have concealed was evidence against you. And
Okay.
then there is also procedures of being a hostile witness. You are not in law required. You swear to provide the information,
Yes.
even that which does not favor you. You also have a
Okay.
responsibility to give material
Present it.
facts to
Okay.
the court.
All right.